Hi, this is Dan Smith of DPS Legal Counsel. Welcome to today's video and podcast episode of Legal Scrubs, where I talk about business issues of interest and importance to health professionals and their healthcare practices. Today I want to talk about the importance of employee policy manuals for your independent medical practice. The first question is, for any medical practice that is out there today, that is running as an independent, privately owned medical practice, is do you even have an employee policy manual? If not, today's the day to get started, because it is really, really important that all medical practices have an employee policy manual. Let me talk about some of the reasons why and some of the bad things that can happen if you don't have one. First of all, it's important to have an employee manual just as a business, as an employer. If you've got staff, if you've got employees, it's important that you have some consistency in communicating what the standards are for operating your business, your practice. Everyone needs to be on the same page as to what your policies are, and the best way to do that is have them written down in a form that everybody gets and everybody can sign off that they've gotten. So in the event that some problem happens, someone breaches one of your policies, and you have a provision in your manual that indicates that there's discipline that follows from that breach, perhaps even termination of employment, you have that clearly stated so everyone is on record as understanding what your rules are. It's also helpful in the event that you do get sued by a disgruntled former employee, to show that you have put rules in place that you follow, and that that employee understood what the expectation and what the rules were. Now, having said that, it's important for you to have an employee manual, and it does help with defense of employment claims by your office staff. You have to be careful about the language that you put into your employee policy manual, because you don't want that policy manual to be deemed to be, or to be argued to be in a lawsuit, an employment agreement or an extension of an employment agreement with a former employee. So you do have to take care in the language that you put in your employee manual to make it absolutely, positively clear as day that the employment manual, the policy manual, does not create a contract, does not provide any vested right in employees for their employment. You have to be clear that your employees, if they are employees at will and they don't have a vested interest in a particular term of employment, that it needs to be clear in your employment manual that they are employees at will and they don't have a vested right in employment, and that the employee manual does not create a contract. So you need to be really clear in your language, have proper disclaimers in your employment manual that make it very, very absolutely crystal clear that the employee policy manual does not create a contract. Now, it's still important to have an employee manual because it does set standards, it does set expectations, it clearly communicates what the policies of your office are, so that you don't have an employee come up later and say, I didn't know I wasn't supposed to do that, or I didn't know that this was against the rules and that's why I got fired. You need to have that in there for that reason, similar to just about any small business. In addition, if you are operating a medical practice, there are a number of other things that make it even more imperative for you to have a policy manual. And the one thing that stands out for that is HIPAA. You know that under HIPAA, you are required to have written policies and procedures if you are a covered entity, and you would be a covered entity if you are if you are a medical practice. And so you need to have written policies and procedures to be compliant with HIPAA that address not only the privacy part of HIPAA, the privacy rule of HIPAA, but also the security rule of HIPAA, how you keep protected health information secure, and then also the breach notification rule of HIPAA, which is what you do in the event you discover there is a breach of HIPAA requirements. And so you probably, if you run a small medical practice, you probably give new patients a HIPAA notice when they become patients that just discusses what their HIPAA rights and how you maintain privacy. But that may not be enough. It may not be sufficient to just do that. You need to have policies in place that are written down so that in the event you get a HIPAA audit or a claim is filed against you, or someone comes looking at you for a possible HIPAA violation, that you can point to your policies and procedures that you had written down and in place and hopefully are following. You need to have policies that address how you keep that information, protected health information, is private. You need to have policies that talk about how you keep private information secure. For example, how you encrypt information, how you keep unencrypted information out of the hands of people who might disclose it improperly. And then you also have to have a policy about what you do in the event you discover a breach and how you notify HHS about that breach. Now, there's a recent case that I talked about on a fairly recent episode of Legal Scrubs involving MD Anderson, the Cancer Center in Houston, Texas, where MD Anderson had gotten a proposed fine from HHS for an alleged HIPAA violation of several $million. And they disputed that fine, and recently the Fifth Circuit Court of Appeals found in favor of MD Anderson and their argument that they should not have to pay the fine for this alleged HIPAA violation. And one of the things that was key in that case was the fact that MD Anderson had put in place an encryption policy that kept protected health information encrypted. Now, in the cases that were brought up in this in the particular case involving MD Anderson, it happened that there was I think 2 thumb drives that had protected health information that had been lost or stolen that were not encrypted, and a laptop that had been stolen or lost and it was not encrypted and it contained protected health information. But the fact that the employees who had lost or allowed the laptop or the thumb drives to be stolen or lost, the fact they hadn't followed the policy was key in the court saying that MD Anderson was not at fault because they had a policy in place to encrypt and the employees just failed to follow the policy. So this just goes to show that not only will a good employee policy manual help you in the event of a possible claim by a disgruntled employee on an employment basis, but it will also help you be compliant with HIPAA, with written policies and procedures for privacy, security, and breach notification. And in the event there is a problem, you get looked at by HHS, or there is some kind of HIPAA disclosure issue, you'll have the policies in place that show that you do require encryption, for example. So all that's to say that if you are a small medical practice, you should make sure that you have this policy in place. And again, it's important to have not only general employee provisions, but also HIPAA provisions. And in connection with HIPAA, since you will be having information maybe provided to your CPA, to your attorney, to billing companies, to consultants, you want to make sure that your business associates who may get access to some of the protected health information are also following requirements of HIPAA. So you want to have in your policy manual that you always make sure that business associates are aware of their HIPAA requirements, and that you always have the business associates who get access to your protected health information sign a good, strong business associate agreement to show that they acknowledge their requirements to keep protected health information of your patients safe, secure, and private. And so all that's to say, if you don't have an employee manual, today's the day to start thinking about getting one. Make sure you have a good one that does not create problems because an employee claims it's a contract, so you want to make sure it has good language, proper language, good disclaimers, but you want to also make sure it has great HIPAA policies and procedures in it. All right, I hope that helps, and we'll see you next time on Legal Scrubs.